Good morning, everyone. Thank you very much for joining us. For some, it's such an early hour. For some, not anymore, I assume. First of all, maybe briefly for everyone to know who we are, where we are coming from, and what type of platform it is. We've seen that there are many people joining us also from Central Asia, a lot of new names. We haven't come across before. So approximately 6 years ago, we have organized the very first conference in Frankfurt, Germany. It was German speaking, which was also concentrated on CIS-related disputes. It was a very successful event, so we decided to conduct the second biannual event in English. So more people and larger audience can join and follow us. And of course, as many other events, the third biannual conference, which was scheduled for February next year, is going to fall victim to the pandemic. So we decided to switch online and to use the opportunity to discuss the most practical and important issues related to CIS region on this platform this way. We've been struggling from the very beginning with the name of the conference because we didn't want to use the word Soviet Union. We understand that Ukraine and Georgia are not parties to CIS region anymore. So it just for all of you to understand, that's how this year we finally came up with the name MOST, which stands for Russian Bridge. But basically what we want to do, we want to really address issues which relate to former Soviet Union countries, specifically from Western European and German-speaking perspective as well. But since the world is changing, we will also be at some point talking to institutions and parties coming from Central or South Asia as well. So Dmitry, now to you, after I've briefly discussed where you're coming from.
Yeah, we've received a good number of registrations from people from Russia, Ukraine, Kazakhstan, the United Kingdom, Cyprus, and other countries. So very welcome to this new platform. We will be recording this session. And please feel free to submit your question via the chat function on the right-hand side of your screen. We've received some questions already, but please submit yours as well. Please also mute yourself and turn off your camera to ensure a good sound quality.
Perfect, thank you very much. So now to the most important issue of today. Today, I'm very pleased that we are going to speak to Dr. Alice Fremuth-Wolf. Alice is Secretary General of one of the leading arbitration institutions when it comes to the CIS region. Itself, the institution is describing as one of the leading institutions in Central and Eastern Europe. So we are going to talk about Vienna International Arbitration Center, about recent changes which the center experienced throughout the last months, but then we are also going to talk about very practical issues concerning CIS regions and the years to come. So welcome, Alice. Thank you very much for joining us. We are very happy to kick off this session with you.
Good morning, and thank you for this nice introduction. I'm very happy to be here today and to speak to such a nice audience.
And we would like also to thank our supporting organizations. The two conferences which Olga has mentioned already were organized on the basis of the German-Russian Lawyers Association in German DRV, who are also supporting us in this new project. We would like also to thank the Caspian Arbitration Society, the CIS Arbitration Forum, and the Ukrainian Arbitration Association for informational support of this initiative. And by the way, one more thing, if you submit your question, please specify whether the question is anonymous or whether we can mention your name. Thank you.
Perfect, thank you very much. Let's dive in. We've been, before this conference, we had a brief chat with Alice, and we discussed that we would like to be as practical as possible, and also a lot of webinars and interviews have already taken place. But there is one major issue we are all facing at the moment, and we cannot be still quiet about the elephant in the room. Especially Vienna is now experiencing also the second lockdown. So Alice, talking about COVID-related changes, I mean, if we think that the starting point for Western Europe, at least, was March this year, we are already more than half a year into it, and we've seen tremendous changes and work that has been done by arbitral institutions. So where do you stand right now as an institution? What were the main experiences which you've taken up to this moment during the last months?
Yes, absolutely. This pandemic is really holding us in its grip for this year. And while in March, everyone was sort of in shock and trying to cope somehow, I think that now we're more advanced and really have developed a strategy. So you mentioned that the second sort of lockdown hit us here in Vienna, and for that we were already prepared, meaning that due to our electronic case management system that even existed for, I think, 2 years now. From the very beginning on, we were able to, conduct our cases and to administer our cases as had been before, because submissions, when we received them by mail, and I think that was really the only change that really we announced to the parties, that for the time being, they should submit all submissions by email only, with, of course, the exception of the statement of claim. Of course, for, when you file the statement of claim electronically, that will still trigger the time period for statute of limitations. So that is fine. That is also enshrined in our rules. But for reasons of enforcement, and particularly relating to the CIS region, I think a proper service of the statement of claim with a proof of that service, that is usually a DHL certificate or a postal certificate, I think cannot be replaced by just an email confirmation that you have received it. It's a very formalistic sort of part of the world. And so for the time being, we really said, okay, I'd submit the claim by electronic means, but then we will still serve the statement of claim to the parties. Okay. So from that point of view, the case management works as usually. All the case managers, they have their sort of laptops, they take it to their home offices, so there's no disruption in that, fortunately for us.
Very good. Very good. I think during the first months of the pandemic also, in addition to the fact of handling and case management and, the fact that people had to move to home offices, we've been talking a lot about hearings, about whether and how to conduct virtual hearings. It seems to me that the arbitration community has moved on in this discussion as well. And we are very pleased, especially to talk to you, as Austria was one of the first jurisdictions, if I'm not mistaken, jurisdictions worldwide even, where the highest Austrian court handed out a decision concerning virtual hearings. Like, can we talk about this development and how much comfort maybe and certainty has been added to this discussion, especially from your perspective?
Yes, with pleasure. I think that's one of the advantages also of Austria being the seat of an arbitration, that we have immediate recourse to the Austrian Supreme Court. And if you think that related to a case that was pending like in April, May, and it was a challenge claim against arbitrators who were holding a hearing virtually against the will of one of the parties, and the other parties objecting, was challenging the whole arbitral tribunal. And that also goes first to, because it was a Viac case, it goes to the Viac board, who, if it confirms the arbitrators, open up the path for the objecting party to directly resort to the Supreme Court. And it submitted the decision in July. So it was a very swift and expected decision. And starting from the beginning, when the pandemic started, of course, at the beginning, what arbitrators did was basically to postpone, because nobody really knew, is this just a temporal period? And I think it's fair to say, in an unforeseen situation when you can't travel, that you first maybe postpone for like 2 weeks, 3 weeks, maybe a month. But when it became clear that this is not going to end soon, arbitral tribunals, of course, quickly adapted, and virtual hearings had been there before. They were not just used as much for case management conferences, for organizational conference. So the tool existed, but it was just not used as extensively. So then arbitral tribunals decided, okay, postponement is not an issue, so let's simply hold it virtually. And then you had those parties who were cooperative and said, okay, good idea, we really want to move on. And then you had others who were not that cooperative and just objected. And I think what the Supreme Court here did is render security, because that was the really, really big issue. What happens if the arbitral tribunal holds a virtual hearing against the will of a party? Will that award be set aside? Will it be not enforceable? So at least I think the Supreme Court has shed some light on how at least the Austrian law works. And it said very clearly that basically virtual hearings are a good thing, because they avoid a standstill of proceedings. And we also have this obligation of due process, of really moving on, of resolving disputes at a cost-effective and efficient manner. And they said it's not sufficient for a party objecting against virtual hearings per se. If it has serious doubts that its rights to be heard are being infringed, or that there is a due process issue, or that's an imbalance, then, of course, the arbitral tribunal, in assessing whether to hold these hearings, has to take this into account and render a decision based on that. But the mere fact that the hearing is being held virtually is not sufficient. To the contrary, it even sort of stated that the use of video conference does not even violate the right of a fair hearing under Article 6 of the European Convention for Human Rights, even if one of the parties objects. And then it talked about two issues that were eminent in that case: time differences and witness tampering. And also held, well, in an international arbitration, people are used that, 9 to 5 is not the usual hour. And if someone has to travel for a hearing around the globe and wakes up with a big jet lag, the question is if that is not more harmful to that person and its ability than probably attending a hearing at an unusual hour. So much for that.
Yeah, maybe just briefly for the audience, if as far as I remember, in this specific case, the claimant, I think, was seated in Vienna, and respondent was seated in Los Angeles, and the hearing was scheduled to be started at 6 a.m. in Los Angeles, and it would be 3 p.m. Vienna time. So that was the time difference, and indeed, half of the globe in between we are talking about. So yeah, from that perspective, because it's definitely one of the reasons many parties are voicing as one of the main concerns when it comes to the fair treatment of the parties. So it was indeed important to hear the reasoning of the court in this regard as well. Sorry, and there was also the issue of witness preparation, of witness tampering.
They said that's and the Supreme Court sort of emphasized that this is an issue that can also happen in in-person hearings, that before a hearing the witnesses are being unduly prepared. So he said there are means also in video conferencing technology that can assure that this is not happening. For example, that the witness is urged to look into the camera at all times, because if you put a close-up on the witness and you see he's sort of, I'm taking my mobile now, constantly looking down, then, you have indications, or that the hands are always seen on the screen, or maybe you have someone in the room observing the witness. So there are several means if this is a real concern that you can take care of. So also, again, just the mere sort of threat of witness tampering is simply not sufficient. So what the arbitral tribunals really need to do is make a thorough assessment and talk it through with the parties, all the concerns that they have, especially if you have the time zones. And I think it cannot be that if you have consecutive hearings or hearing dates, that always one party is played at a disadvantage. Like starting a hearing one day where it's 6 a.m. for one party, but probably the next day it's going to be the other side who is facing. I think we have so much flexibility. We can have shorter hearing dates. So I think there's a lot that arbitral tribunals can do to secure that there is no undue or unequal treatment of the parties in that respect.
Definitely. No, and indeed, it seems like that this decision will or is providing great comfort, first of all, to arbitrators rendering this decision, and is basically providing, in a way, a checklist for parties and for arbitrators of the issues which should be considered. And speaking about checklists, so Vienna was also, again, like I think a lot of arbitral institutes and institutions worldwide put a tremendous effort in helping their users to cope with the situations. And one of the offerings of the Vienna International Arbitration Center was the so-called Vienna Protocol on virtual hearings. Also, do you see arbitrators and parties in the proceedings which which are pending or have been initiated in recent months, that this guidance is being used?
Yes, absolutely. Actually, it was the reason why we came out with it, because we kept on receiving the same questions by the arbitrators. What platform should I use? Is it permissible to hold hearings against the will? What do I have to look at? How is the regulatory framework in Austria? And so on and so on. So I think, of course, I understand that arbitrators and parties, they would like to have a ready-made solution from institutions saying, okay, it's permissible, use this platform, and if you do that, then you will be safe. But it's not as simple, because every case is different, and what works well for one case might not work well for the other, because we all know we have used many platforms by now, Zoom and WebEx and you name it, and Google, and for some regions, the connectivity is simply not good with one platform. So that's why we thought it's good to have this checklist that really provides sort of a guideline for the arbitrators on all the issues, like check boxes that they need to consider before they give the green light to the hearings, and also for the parties to ensure if all that is being answered, then they can be pretty sure that they have not forgotten to think about issues like testing, having a fallback platform, looking at the regulatory framework of the seat of the arbitration, of potential enforcement states, because if you might have in a particular country a Supreme Court decision saying virtual hearings are not permissible, then it doesn't make sense to hold it, even if under your jurisdiction is fine if you can't enforce the award. So I think these are the issues. So we really wanted to stress that preparation and organization in advance is key, especially in the virtual setting, probably much more than for an in-person hearing.
Absolutely.
Yeah, we've received a question on that, whether we are aware of any practice of enforcement of arbitral awards based on virtual hearings. And maybe I can add to that, the Supreme Court decision of Austria, you refer to concerned challenge of arbitrators, not to the challenge of an award. Does it mean, in your eyes, automatically that any award is safe now under Austrian law for a potential set-aside motion or enforcement of a foreign arbitral award?
Definitely, I understood the Supreme Court, and I think he wrote it in between the lines, that if it's not sufficient for a challenge, and he really put a strong word that virtual hearing against the will of one of the parties is not an infringement of Article 6 Human Rights Convention, not of the right to be heard. So under these are also criteria where you can ask for setting aside of the award if the right to be heard was being infringed, and definitely this will not be the case, provided that under this particular case it was really not so. So, I mean, it's not a free rider or free wave for all hearings to take place virtually against the will of the parties, but the arbitral tribunal has to show in its assessment why it came to the conclusion. but it's not a per se sort of situation.
Yeah. No, but indeed, I think still it's, again, as you said, there are a number of criteria has been considered and listed and deliberated on by the Austrian court. And especially also, it's very important to mention Article 6 of the European Convention on Human Rights, addressing, due process and fair, the right to be heard. So it does provide a foreseeability and predictability, at least when it comes to arbitration proceedings seated in Vienna or seated in Austria, and maybe even in a way within the region of the Western Europe and parties of the European Convention on Human Rights. At least it gives one a glimpse of perspective how other courts and jurisdiction might approach this issue as well. In terms of, Dmitry, do we have also if we have any questions coming in at this time, we're happy to take.
We have one question on that topic, whether you see a perspective to come back to hearings in person, or do you believe that such a hybrid hearings or even virtual hearings will stay after the pandemic is over, hopefully soon?
I definitely think that the virtual hearings will become standard for certain parts of the hearing. As I said, case management conferences, organizational hearings, maybe if it's only about a legal point, because people have seen that it works pretty well and everyone is sensitive about cost, effectiveness, and I think we have just experienced sort of involuntarily how we can conduct hearings in a very sort of cost efficient manner. Probably it's not for all the hearings, but for those where it works fine, I think there will be no justification whatsoever, and parties will not be willing to pay for costly case management conferences that last 3 hours for a whole crew of arbitrators and counsel to just travel around the world. Yes, I think definitely it will stay.
Do you see maybe, oh, sorry, Dmitry.
No, come on.
No, I just want to ask you whether you see it as a benefit also and advantage for Vyak, because based on my experience, I've been involved in Vyak proceedings where dealing, for example, with Central Asian parties. So Vienna would be chosen as a seat of arbitration, but otherwise like parties would be allocated elsewhere. And I think also depending on the complexity, but also amount in dispute, it might really be a very cost-effective solution, right? For those parties on the one side opting Vienna as a safe and predictable legal environment, opting Austria as the seat of arbitration, Vienna as a seat of arbitration, and on the other hand being, seated in completely different jurisdictions physically.
Absolutely. I mean, even though it's not a necessity to hold the hearings at the place of arbitration, it has become a habit. And, before the pandemic, traveling and coming to Vienna was also a quite nice side effect. But I think we have to think ahead. And if you say, and I think that's really the message, if you really say that you want a safe harbor, a safe seat, but at the same time want to have utmost flexibility with holding the hearings, then virtual hearings is the perfect solution, I think.
And you've mentioned a electronic case management system, which you have at Viac. Maybe you could say a few words more. What exactly is electronic? Is it email only? Is there a platform?
Yeah, well, we have implemented the first step of the electronic case management system, I think 2 years ago, because before that we had sort of paper cases. So all the cases were printouts, because even I think 10 years ago, much more was being sent by post, submissions, statements, and so on. Then we had this shift, and so we received most of the issues electronically. So what we did is simply set up an electronic case management system where all the case material is sort of saved in this electronic system. So all the case managers can immediately at the same time access all the different cases. And of course, it allows us also to search for issues, to have better statistics. And it's a really, but it's only an internal database for us, for the administration. So since that is established, and I think also here the pandemic worked as an accelerator for us, we decided to go for the next step, to the next level. And we have made an agreement with HiQ. We have a license for the platform of HiQ, and we are just preparing it for the launch in 2021, where we will also offer the parties and the arbitrators in our cases to use this platform. We will call it the Viac portal, to use it in their cases, to also communicate within the case, to upload, to download, because we really want to get away from email, which is, I think, not that safe. And simply also, when you submit everything by email, you have huge, I think, problem somehow getting through emails with a large data amount. And we will use it also for our communications with the parties.
So just to imagine, it means that it would be a platform where parties and arbitrators would log in and would have access to their respective folders.
Exactly. Yeah, there will be a claimant folder, respondent folder, a tribunal folder. So when submissions are being due, they can be simply uploaded in the respective files, and it will be visible and really traceable who has accessed what. You can't delete files that you have once uploaded, but we're just working now on the specificities, how we really want to shape it. And I think it will be a great help and assistance to tribunals and parties to really structure the arbitrations and make it even more efficient.
That sounds very good. And indeed, it would address also the security issues with email providers, right?
Yes.
Okay.
Absolutely.
We've received one more question from Lilia Klochenko, who is asking, traditionally a younger generation is an expert in technology. Do you think that it might influence the age profile of the pool of arbitrators in the nearest future?
It could be, although I have to say age is not necessarily a hindrance for tech affinity. I think there are many arbitrators out there who, especially in an international environment, were used of having their files on their laptops, on their platforms. So yes, it could be because we grew up, but it's not a necessity. But definitely it will be one of the criteria in addition that we will look at when we as institutions make appointments. Is that person also willing and able to probably conduct proceedings in a virtual manner, or is that a completely old style sort of person?
Interesting. So, there is, I'm looking at the issues we wanted to discuss. Dmitry, what do you think? We talk about mediation and then move on to CIS-related specifics.
Sure.
We've noticed that Vyak also launched a so-called mediation initiative during the COVID time, also looking at the developments throughout the last months, it seems that a lot of pending arbitration litigation proceedings went actually into mediation or settlement negotiations, which might have been prompted by, financial standing of the parties, by the pandemic and its effects. So is this offering an immediate result of the pandemic, and how do you see it evolving going forward?
Well, absolutely. This mediation initiative was basically born out of the pandemic. We have our set of mediation rules since 2016, but we have seen that parties have not been using it as much as we thought. But in the pandemic, we really thought, what could be a real assistance to affected undertakings that have a contract that is being disrupted? Maybe you have a force majeure clause in your favor, maybe against, maybe there's none, but fact is that both are affected by the situation, and there is no it's nobody's fault. I mean, nobody could foresee it. So what we thought is, what we do is we approached via our Austrian mediation advisory board. We approached the Austrian community of mediators, and we asked them who would be willing, under a sort of arranged framework, to offer mediation services at a reduced level for COVID-related disputes. And we found a nice pool of mediators who said, okay, we're up to it. And then we promoted it, and we said, if undertakings, and we specified it because we didn't know how it's going to work. First of all, if it's an Austrian undertaking being involved, it didn't have to be a domestic Austrian dispute, but at least one Austrian undertaking being involved who has a dispute related to COVID and wants or needs a mediator. Then those parties can send a request to us, and we will, according to the criteria that the mediator should fulfill, select the mediator from the list. And this mediator will get in touch with the parties and take it from there with this pre-arranged fee arrangement. And I think it was very well received. We had some requests. I think some more are still to come. And I think it was just for us an immediate reaction and the service that we can provide as institutions, because parties might have more trust if it comes from an institution.
Yeah, one should mention also in this context that you were not, so Vyak was not claiming any administrative in this construct. It was a very streamlined procedure and like true offering. In international perspective, do you see that mediation is going to play a bigger role, and especially in view of the Singapore Convention that came into force in September, if I'm not mistaken, this year?
Well, I think the Singapore Convention definitely has played a big role, but as long as not enough states have ratified it, I think it's going to be a bit problematic. But what I see is, for the time being, that mediation within arbitration has really become I have seen it very often in my recent cases, that the parties at some point in time, and especially for those cases that were pending at the pandemic, I had various cases that were being halted, where a mediation window was being opened, even sometimes with our assistance, sometimes without the assistance, and the parties would then come back with their settlement and have the benefit of having an award on agreed terms. That is still enforceable under the New York Convention. That's one of the issues, I think, until the Singapore Convention really has the same reach as the New York Convention, this sort of mechanism of having this one-stop shop, starting your arbitration, because sometimes you really need to put something on the table. You also want to, hold the statute of limitations, and then the other party basically wakes up and says, okay, now it's getting serious. Let's talk. And I think with that, and again, under the Viac rules, you can have that, and we will not double charge parties with administrative fees. So it's all within one go. And I think that's really something that is being quite frequently used nowadays.
Interesting. Thank you. So let's come to our CIS bit.
Maybe one more question on the Viac organization, if I may.
Yes.
A huge number of institutions, arbitral institutions in Eastern Europe and the CIS region are usually, they exist at the Chamber of Commerce of the respective country. Viac is also attached to the Economic Chamber of Austria. Maybe you could say a few words about the relationship between Viac and the Economic Chamber.
Yes. In 1975, the Austrian Chamber of Commerce decided to found or to set up its own arbitration institution, the Viac, especially for East and West related disputes. So actually, that is the historical background, Cold War and all that. So that is actually why we were founded. But we were always sort of a department within the chamber with our sort of separate, I would say, separate offices. And with that, I mean that there is really a Chinese wall between our offices and the rest of the chamber. So the mentioned case management system and also even our email system, they are detached from the chambers, and it's really secured that only our staff has access to that. And in addition, in the law and even in our rules, it's enshrined that we are all not subject to any instructions from the chamber, from the management, or from everyone. So it's not possible that the president of the chamber or any other superior official might claim access or knowledge into one of the cases, or even urge us to appoint a certain person, because this is simply prohibited by law. And as far, it has never happened. I mean, the Austrian chamber is a huge chamber with a lot of issues to tackle, and we have always been our sort of independent bit. But yes, I'm an employee of the chamber and I get my remuneration from the chamber, but that's about it.
Alice, you have just mentioned that historically, the offering was provided in the context of the Cold War. And again, like looking at the websites of the institution, Viac is describing itself as a leading institution for Central and Eastern Europe. It seems to me so that at least I noticed the growing presence of Viac also in Central Asia. Is it a right perception? Is it, area where you also see more cases coming in from?
Yes, definitely. I think it's sort of stretching. The East is sort of stretching, and we have seen interest also from parties from these countries who probably feel more related to us for international disputes than maybe to Hong Kong or to Viac. I'm just talking about sort of countries like Uzbekistan, Georgia, Azerbaijan, etc., because their heart sort of basically lies more in the European sphere than probably in the complete Asian sphere for backgrounds. And we have also concluded a cooperation agreement with local arbitration institutions, simply to signalize that we also want to assist. We want to assist building up their local arbitration practice, which we consider very important, because I think really each country needs also the local institution taking care of the domestic cases. And then it's another issue, what do you do with an international case? But I really truly believe that the backbone, the domestic backbone and a domestic institution that is well rooted and accepted is key in all of these countries.
And talking about the geographical outreach, what's the current percentage of cases relating to Central and Eastern European parties in your practice?
It's, I would say it's a third. A third of the parties is from Central and Eastern Europe. 1/3 is from Austria, because very often you also have an Austrian party involved. But and 1/3 probably 1/3 is the rest of the world.
And you are also only one of the two arbitral institutions which have received a so-called license from the Russian government to administer Russia-related cases. What was the motivation of Vyak to apply for such a license, and how did the procedure go?
Well, when we learned about Russia's change in system, that they wanted to instigate this license system, we really sort of understood their motivation, because there had been these pocket arbitration institutions, and we really had an understanding why they wanted to change something about that, because they didn't want this to be continued. So what we did very early on is stay in a dialogue with the Russian authorities and people within deciding on that issues, and giving the outside perspective of what does it mean for a foreign institution to submit itself under a license system, what is probably asking too much, what is simply fair to ask, and really try to give this very proactive input from our side. And when we had the feeling, and I think it was really a process, that we could easily sort of fulfill the criteria, and we also wanted to fulfill the criteria, we made the decision to apply, because first of all, again, we wanted to signal our cooperative attitude, that we didn't think that a license system per se is something negative. It's just, you know, how you draft it and what criteria you ask from an institution. And the process for me was very positive. I felt very welcome, very well received when I had the presentation in front of the council. I was prepared to ask all the questions that were being put in front of me, because they really wanted to assure that we take this seriously, which we did. And basically the motivation was for all parties in Vyak cases to ensure that awards that are being rendered will be enforceable in Russia and not fall under the ad hoc regime, which I understand is much more cumbersome, but falling under the favorable institutional system.
Interesting. It's and maybe like talking, you know, first of all, I think really it's a very positive sign that Viac was one of the very two, I think, Hong Kong, right, was the other institution that went.
Yes.
For the dialogue and for the license, which is important, right, to also to provide services, as you say, to your users envisaging potential enforcement in Russia. Talking about enforcement specifics in general in the CIS region, I mean, you've touched a bit already on this issue when addressing e-filings and current environment. Are there any other specific practical concerns counsel and arbitrators should keep in mind when dealing with CIS-related disputes?
I think there are two critical points. It's the beginning of the arbitration with the service of the statement of claim. This is really, really important, but that is more for the institution to take care of, to really only start the arbitration, or, you know, to make sure that you have a proper service of proof. For the you know, conduct of the proceedings, maybe the attitude is a bit more formalistic, as I said before, of the parties, wanting the tribunal really to take the lead, and not like the common law system where, you know, the council is doing basically the work and the tribunal is maybe sitting back and leaning back. So much more proactive approach. And when it comes to the rendering of the award, I think for the time being, unless we have a system where also electronic signatures, secured electronic signatures on documents are recognized on a worldwide basis, sort of via the Hague Convention, etc., I think it will still be necessary to really issue the award on paper. And I think we're doing, we still maintain this sort of exercise that when putting the award together, we have the emblem of the Austrian eagle, we have a stamp, and we seal the award in order to ensure that no pages can be tampered. And I think that has really made the difference. And I have not heard that any sort of Viac award was not enforced in that region due to formalistic reasons. Maybe other region, other issues, but you know, that's another topic. But to meet these formalistic requirements, I think that's very important.
We have received a question which doesn't really concern the CIS specifics, but maybe I can, in the interest of time, ask you that question. It's a rather long one. It concerns data protection and the use of video conferencing. The question is by Axel Boys from Hamburg. The use of video conferencing systems, Zoom, for example, we had a discussion and there are strong concerns with regard to the use of Zoom Microsoft Teams, etc., since there is a recommendation from the Berlin Data Protection Officer that none of these systems comply with the European Data Protection Regulations, the GDPR. Two of the main issues here are data processing outside the European Union and whether a correct data processing agreement can be concluded. And the fear is that the arbitrators who organize the video conference are liable under the GDPR, and that using Zoom or similar does not allow them to comply with legal requirements. Do you have an opinion on that?
Well, the data protection definitely has put an additional dimension, and when you meet physically, you don't have that issue simply. But yes, I do agree that the GDPR is one of the issues that the arbitrators have to take into account when deciding which platform to use. And if you have such a recommendation, then probably it would be wise for not to use that system. But I think this is really to be assessed again on a case-by-case basis, or together with the parties, because simply these are huge implications, and we are in contact with other arbitral institutions to constantly assess the data protection impact on the arbitral process. But it's definitely an issue.
Maybe, I mean, it's a bit, you know, I think it's one of the probably, well, future, but maybe like, you know, immediate future topics, but maybe it will, you know, one of the, it will be one of the concerns which could be addressed, for example, by the platform, like we've discussed previously, right? Depending on where the data is stored, and indeed, well, it depends. I think what we will see is that we will see more and more providers coming with an offering of like data storage within the territory of the European Union. That is also true, for example, Microsoft Teams, if you opt for a specific offering which already exists, where data is stored in the European Union. And even since this year in Germany, because Germany applied, you know, additional on top of the GDPR regulation, and probably we will see more and more offering of this type coming in. You've mentioned also that you are, you know, this is one of the issues which is addressed in discussion and collaboration with other European institutions. Sorry, it's me who didn't manage to mute parallel telephones. Speaking about other European institutions in the CIS-related context, where do you see Vyak? What are the main advantages in comparison to other players that are also active in this market or in this geographical region? Let's put it that way.
Well, I think what is key is predictability and stability, and having made yourself a name and a presence in the market for quite some time. So we are around since 1975, so people really have trust. When they hear Viac, they know, okay, this is an institution that can be trusted, that has predictable rules. We don't change our rules, you know, frequently, and if we do, we really try to be careful to keep the rules within this lean and flexible structure that we've had for a long time. So just to give you an example, when the issues with virtual hearings came up, there was no problem with the Viac rules, because the wording is such that oral hearing can mean anything, whilst other institutions, for example, the ICC, they had a topic because their rules are much more tightly knitted for various reasons. So I think that is one of the advantages if you have lean and flexible rules. The second is that we always try to be very cost sensitive when it comes to administrative fees, also to arbitrators fees, especially for smaller amounts in dispute. And I think we're very competitive in that respect. And then we have tried not to follow all sort of the trends that have come up, for example, emergency arbitrator. I think it's a good tool for some institutions to have it, but not everyone has to follow, and we have deliberately decided that we do not want to have it. And I think this is also something to bear in mind, because I know a lot of parties who are not very fond of the prospect that in addition to an arbitration, they can also be faced with an emergency arbitration.
Coming back to CIS-related arbitrations, is there any special feature which you regularly see, be it the appointment of arbitrators, the language used, the applicable law, or are the cases similar to all the others which you have?
They're pretty, I mean, I can't see big differences. What surprises me sometimes is that, for example, the language in the arbitration agreement for the arbitration to be conducted is very often English, even though it could be any other language, for example, Russian. But probably the reason is that a lot of people still use a standard clause, and they don't consider how they could change and modify it to really fit it to the particular needs. And also when it comes to the appointment of arbitrators, I think there are so many great practitioners nowadays in the CIS region that I'm sometimes surprised why still arbitrators, you know, from, I would say, the West are being appointed rather than those available people in that particular market. And that is somehow surprising for me. But maybe this is going to change in the future. But apart from that, no particular specificities.
No, but I think that those are very interesting points, and I hope it is very encouraging for some of our audience and listeners that from the CIS region that you know, arbitrators and specialists coming, experts coming from those regions should be considered, as you rightly say, because they are already also very experienced and dealt with many proceedings seated in or placed in Western Europe as well. So we have 5 more minutes left. Dmitry, I don't see any immediate questions, so maybe we can come.
Yeah, maybe we haven't received any further questions from the audience. Maybe one more point which we should mention briefly. And it is usually reported that in arbitrations seated in Austria, Switzerland, and Germany, there is a relatively high number of settlements. Is it also the case for Vyak arbitrations?
Well, usually no, but I think now in these times I can see an increase in settlements. Although sometimes you can't really tell. You know, we see claims being filed, and then before the case is being handed over to the tribunals, you know, the claim is withdrawn. Whether this is due to a settlement or no, we don't know. But I think still 1/3 of the cases probably ends without an award.
Thank you.
And maybe I can say just one word because I forgot to mention that we also paid a lot of effort in providing our rules in different languages to the parties. So there is really no need just to resort to the English versions we have on the website. We have it in Russian, we have it in Czech, in Polish, in Ukrainian, in Romanian. So we really tried also to be hands-on for people on site to make themselves familiar with the rules, and also our staff here, even though the language of administration is German and English, they speak many languages, which is quite useful when you just want to call as a counsel and you can ask the question in your native language.
It is indeed a tremendous amount. I mean, I don't have the exact number at the moment, but it's above 10. So I think more than 10 languages are spoken by the secretariats, which is, you know, I think a very, very practical and exceptional aspect.
Yeah, I'm very lucky with my team.
Very good. So yes, we have just a few minutes left. We had one block envisaging a discussion about an outlook, and I think it's a specifically challenging block in such times. we are in right now. So where do you see Vyak in 10 years, but also in view of the recent changes, what do you think are the core qualities of arbitral institution which would, you know, bring it through the next 10 years, whatever they might be, or however they might look like?
I think the advantage of arbitration has always been its flexibility, its immediate ability to adapt to changing circumstances. And I think in opposition to the state court system, which is much more rooted and much more sort of inflexible, I think we will simply have to see what the users need. If there is a shift towards mediation, because this is what users want, then we need to adapt. And I think those arbitral institutions will remain and stay in place who are really able to meet those needs and not just stay there for the sake of it and be there because they have always been there, but really try to touch base with the audience, touch base with the parties out there and get into a dialogue and see what is it that they really want. And it's hard to predict in 10 years' time what is going to happen because nobody even a year before knew what we would be facing now a year afterwards. But we have to keep our eyes open. I predict there will be some ODR systems where you will have probabilities whether you can win the case or not, given the particular circumstances. So I think the users will become more sophisticated, and we simply have to be alert and just go with the flow.
Very good.
Thank you very much. I think we've reached our time limit.
Exactly, and it sounds like it's been a perfect conclusion for arbitration on for Vyak institution as well.
Thank you very much for the interesting discussion. It was a pleasure having you as a guest.
Thank you very much, Olga and Dmitry, for this great interview. I enjoyed very much.
Thank you. Thank you. Good luck. Stay safe and healthy to everyone. I mean, this is a sentence which cannot be missed during the recent times. We are looking forward to getting together one day again at some point with pleasure in Vienna in person. But until then, it's been a huge pleasure and we are very grateful for having learned so much during this session in this format. Have a nice day, everyone. We are going to continue the conversation, and indeed in December we plan to talk to ICC Council also about CIS-related disputes and the recent amendments to the ICC rules. So everyone who is interested in this, please stay tuned, and we will post the link on LinkedIn in the coming time. Until then, thank you very much, and I hope to see you all soon.
Thank you very much.
Goodbye.
Goodbye.
Bye.
Have a nice day. Bye.